All right. So it appears none of that helped you, that you disappeared and you continue to use controlled substances. So why? I don't, I don't think 2 years is appropriate. And let me just explain to you all why. This is not his first motion to revoke. And the previous motion to revoke, it was a violation of condition number 2 and condition number 5. I heard that motion to revoke. So I know he was transferred to Washington County in Arkansas because that's what he requested. And so he was transferred there. And it appears that they did an inpatient treatment there. And then he immediately goes back to doing what he's done before, which is abscond and continue to use.
A Texas courtroom, a Tuesday morning docket. The judge is already working through cases when Brandon Murray is called to the bench. The year is noted in the record as 2015 CR 1 2011.
All right, the court is calling 2015 CR 12011 State versus Brandon Murray. Could I have parties announce? And are you Brandon Murray? All right, did you review the document entitled Motion to Revoke Community Supervision and State's motion to supplement pending motion to revoke probation with your attorney? Did you understand it? Are you the same Brandon Murray who was placed on community supervision in 2015 CR 12011 for the offense of assault family second offense on November 15, 2016 for a term of 5 years and extended for a term of 4 years? Is that you? All right, state.
Supplement violation of 5 in Barrett County, Texas. The defendant, Brandon Murray, then and there failed to report to the supervision officer as directed for the months of August.
The original offense was assault, family violence, second offense. That conviction placed Murray on community supervision in November of 2016. 5 years, then extended to 4 more. He has been under court supervision for nearly a decade. The motion before the court is a revocation. The state wants his probation terminated and his sentence activated. The specific violation is condition number 5. You report to your supervision officer as directed. The record shows Murray failed to report for 2 separate stretches, August through December, then January through September, nearly a year and a half combined across 2 gaps where the court simply had no idea where he was. Community supervision in Texas is not imprisonment. It is a contract. The state agrees not to incarcerate you in exchange for your agreement to follow specific conditions. Those conditions exist because the court needs to verify on an ongoing basis that you are not a danger to yourself or to others. Reporting to your supervision officer is the most elementary condition on that list. It is the mechanism by which everything else is confirmed. When you stop reporting, you break the circuit entirely. The court has no visibility, no accountability, no way to know whether you are getting treatment, committing new offenses, or both. Murray pleads true to the...
How do you plead to that? True or not true? True or not true? Any objections to the waivers?
No.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, sentence you up to 6 years in the prison, a $1,500 fine? Knowing that, do you still wish to plead true to violation of condition number 5?
Violation. His attorney presents documentation. While he was in Arkansas living with his grandmother, he completed an inpatient drug and alcohol program, 9 months. The certificates were never transmitted to the Texas Probation Office. The paperwork did not follow him across state lines. The attorney presents the certificates in court and asks the judge to consider them in mitigation. The proposed agreement is 2 years.
Form is sentence sentence the defendant to 2 years. Please.
All right, is that the proposed agreement?
Yeah.
The judge pauses. She has heard Murray's name
And let me just explain to you all why this is not his first motion to revoke. And the previous motion to revoke, it was a violation of condition number 2 and condition number 5. I heard that motion to revoke, so I know he was transferred to Washington County in Arkansas because
before. This is not his first motion to revoke. On the previous motion, there were violations of Condition 2 and Condition 5. At that prior hearing, Murray requested a transfer to Washington County, Arkansas, to be closer to family. The court granted it. The state facilitated the transfer. The inpatient treatment followed. And then, by the record before the court now, Murray absconded again and continued using controlled substances. The pattern is not ambiguous. The judge names it directly. He did the program. He came back. He disappeared again.
so they, according to this, you continue to struggle with sobriety and you continue to have criminal behaviors. So, I mean, for the court, I don't know why I would give you the minimum sentence when I don't know if you've even really been trying, because the number one thing and the easiest thing to do is show up, whether you're using or not using. The easiest thing to show is to show up, and you disappeared.
He kept using. The judge asks Murray what he was doing when he disappeared. His response is partially captured in the transcript. He says he was young. He mentions his child. He says he was helping care for a 7-year-old. The judge stops him. She asks what drug the record shows he was using. The answer is meth and cocaine. She asks whether someone in the grip of that level of addiction should be trusted to watch a child.
Oh my goodness. That shouldn't even be happening if he's in the throes of his drug addiction. And according to this, it's meth and cocaine, and somebody's trusting him to watch a child. That just should not be. And you know it should not be.
So, sexual, so. That's how it was.
Murray does not argue the point.
Let me ask you this. How old is your child?
So,
Your child is 7. If there were someone who had your criminal history, would you want them babysitting your child?
Then Murray says something that changes the calculation. He tells the judge the substances got into his system because he was selling them. His attorney had presumably framed this as an explanation, perhaps an effort to suggest he was not personally struggling with addiction at that moment, but was instead dealing product. The judge considers this for a sentence and then responds that for cocaine and methamphetamine to appear in a probation drug screen at the levels that would be consistent with that explanation, he would have to be moving a significant quantity of material. She tells him that selling controlled substances while on felony probation for family violence is not mitigation. It is additional criminal behavior.
And the fact that you're standing before me telling me that you were selling, that's how it got in your system. One, that's not 100% believable unless you're moving a lot of material. And 2, that's not good at all. That's what they mean in that report when they say you're continuing with your criminal behavior.
The report had flagged ongoing criminal conduct. This is what it meant. The judge declines the 2-year agreement. She sentences Murray to 5 years in the Texas Department of Criminal Justice.
Court is finding 5 true. The court is going to sentence you to 5 years in the prison. Court will give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with the complainant in this case. There's to be no residing in households with minors. There's to be no unsupervised contact with minors.
She issues an affirmative finding of family violence, which carries legal consequences that extend past the sentence itself. She enters a no-contact order with the complainant. She orders no residing in households with minors. She orders no unsupervised contact with minors. Murray also has an outstanding Arkansas case, a separate matter carrying a 72-month sentence. The judge runs the Texas sentence concurrent with that case number. He receives credit for days already served in Arkansas's custody.
All right, so that would be, okay. Okay, that would be run concurrent with that cause number. Is there anything else from either side with regards to sentencing? During the what?
136 days he has credit over there in Arkansas, and 154 days he has credit here.
All right, he'll receive the 176 days credit in Arkansas.
After the formal record closes, the judge speaks to Murray directly.
Says, one, you shouldn't be selling. You have a child to take care of. Two, that your grandmother is now being a great grandmother / parent to your child because you can't step up in the plate and you're not dependable. You understand? And where's your mom and dad? I'm sorry to hear that. And your father? All right. And so everybody is putting everything on the grandmother to do all of this. And you are continuing to have children and not be the type of person who should have children or who can take care of children. You understand? So do not go visiting that to your grandmother's doorstep. She doesn't need it. What you can do is get a job when you're released and send money to your grandmother for taking care of your child that you're not doing. And don't go in that child's life causing destruction. You understand? All right, good luck to you. You're welcome.
She does not raise her voice. She tells him his grandmother is functioning as a parent to his child because he is not. She tells him not to return to his grandmother's home and add to her burden. She tells him to get a job when he is released and send money to the woman raising his child. She asks about his parents. The transcript captures that his mother is gone, and his father is also absent from the picture. She acknowledges this. She does not soften what follows. She tells him that he is continuing to have children he cannot care for, and that he should not bring that instability back to his grandmother's door. She wishes him luck and moves immediately to the next case. The case of Edward Rise follows. Burglary of a habitation, a second-degree felony, carries 2 to 20 years in Texas. Reyes has a plea agreement for 10 years. The judge processes the admonishments in sequence. During the brief conversation after sentencing, his attorney confirms that Reyes's presence before the court is connected to mental illness. The judge makes a referral to the therapeutic community program within TDCJ. She notes that she cannot compel the prison system to enroll him. He will have to request placement himself. She tells him his job is to take care of his mental health and moves on.
All right. So you're going to have to make sure you take care of your mental health, okay?
Victor Guzman's case does not resolve that day. His attorney filed a motion to suppress evidence the day before the hearing. Under the code, the defense is entitled to 7 days to prepare such a motion. The state has had the same 24 hours and is not prepared to concede the suppression issue. The underlying facts involve a car parked at a convenience store, officers approaching the vehicle, a temporary license plate irregularity, loose bullets visible inside the car, and a subsequent search.
No, I mean, is it a search warrant? Is it
there's no
a stop?
No, it's a vehicle that is parked at a convenience store. And so the officers come over to the convenience store, tell them to move away. And that's something the license, temporary license plate they have returned. They were checking on it. Apparently they saw some loose bullets inside the car and then they searched it.
The legal question is whether the officers had sufficient grounds for that search.
All right. So, State, have you had a chance to review the defense's concerns about the suppression issue or no?
We've only gotten this as of yesterday, Judge.
All right. So State, look over that, see if you're in agreement that it should be suppressed. If you're not in agreement, then we'll have a motion to suppress hearing. And
Judge Lauren is actually running lead on this one, but based on what she and I were speaking about, I don't think we'll be in agreement that I think it should be suppressed.
mhm.
The judge sets a suppression hearing for the week of June 15th. Both the defense attorney and the lead prosecutor on the state's side will be in New York that week. The hearing is reset. The docket continues. A defendant named Morris Thompson was supposed to appear, but is not in the courtroom and was not on the Zoom call the day before.
Where is Mr. Morris Thompson?
I don't know, he apparently called the office and he said he was on Zoom
He was never on Zoom.
yesterday, so I don't
Yeah.
know what happened.
Yeah, so he needs to be here today. So I'm gonna recall it. Is he out of county or what?
And I think so, I mean, his area code is from somewhere.
4. The judge instructs staff to determine whether he is in county or out of county and adds him to the docket for the 29th with a notation that he needs to appear in person.
Put him on the same date, that 29th date, and he needs to be here in person.
The record from this single morning docket contains 3 cases at 3 entirely different stages of the criminal process. A revocation hearing where a judge departs from a plea agreement and explains her reasoning in plain language on the record. A plea and sentencing where mental health is acknowledged but not fully addressed by any mechanism the court controls.
All right, so his being here, did that have to do with mental illness?
Yes.
Okay. All right, the court will sentence you to 10 years in the prison. Give you credit for any time served. There's to be no residing in households with minors. No unsupervised contact with minors. And I'll do a referral to the therapeutic community. It doesn't increase the time that you're in custody, but it's to help you with any type of mental health issues or anything else. I don't have any jurisdiction to force them to place you in the program. You'll have to request it.
Roles, and a pretrial suppression dispute that will turn on whether officers at a convenience store had enough legal justification to search a man's car. Each case resolves according to a different logic. Each outcome will be lived by a specific person for years. What a morning docket in a Texas courtroom shows you is not dysfunction. It is the system operating at its intended speed, making permanent decisions about human lives in the time it takes to process a routine insurance claim, with a judge who is informed, attentive, and still cannot do more than the law in front of her allows.